Hello, my friends, and thank you for coming back for the second hour of the Melanie Little Show today. It is Friday, July 12th, 2024, and we are here at 2:50 p.m. on the East Coast. Breaking news with Mark Bederow to bring you Commonwealth's opposition to defendant's post-trial motion to dismiss. I haven't even looked at it yet. Have you?
Yeah, it's what you'd expect. It's written by zombies for zombies, and um, I mean they make fair legal arguments, but they just don't know how to read the room and are tone deaf about the most basic constitutional rights. I mean, they could oppose this, but in a way where they have a little bit of class in how they do this. And not to jump ahead too much, but I think what's going to happen is ultimately, if the judge denies all this on the papers, all it's the people who are going to be offended more than the Karen Reed supporters, more than the defense, are going to be the jurors who are going to be denied an explanation of what happened, because they're the people, if this gets denied, who have to live with the fact that we acquitted a woman who may very well get retried for murder. And that's a hell of a thing to have on your conscience, I would think. And if the judge doesn't want to hear it and the DA doesn't want to hear it, then there's no one left to hear it other than the public. And I think that's what ultimately is going to happen.
Yeah. Oh, really? That's interesting. Okay. Melly, thanks for the super chat, says Melanie. And Mark, you are amazing. Thank you. There's an issue right now with StreamYard not highlighting the super chats. So I'm going to do the best that I can to put them in their proper column the way they're supposed to be handled here. But forgive me if I don't catch every single one of them. All right. So let's take a look. The Commonwealth's opposition to dismiss this motion filed just this morning. We're always hot off the presses, Mark. For those of you who weren't here for the past hour and about a half, I had Craig Bates, also known as Tiny Desk Guy, AV Squad, for the defense team on for about an hour and a half. And it was a great show. If you didn't watch it, go back and watch it later. I don't know if you saw it, Mark, but it was really interesting to hear all of Craig's thoughts.
Like 15 or 20 minutes of it. And I saw the part where he was or the lawyers were getting chastised for him. What was the word? What did he say that he was doing?
He took liberties. He took liberties. Because he came in the courtroom one day when she didn't know he was going to be there, when they were in the bigger courtroom, and he sat next to the defense team at the table.
I had never seen that before. A lot of the pretrial stuff I've never seen, and it's like the same pattern. There's just this constant cantankerous misery. It's kind of sad.
I mean, that's a great word.
Well, isn't it though?
Perfect. It's the perfect word.
I mean, I just feel like she's Judge Cranky Pants. I mean, why so cranky all the time over everything? And it's even the pretrial hearings during the trial. You can be sure when she denies this motion, she's going to point at them and say, it's your fault for not objecting, and you could have done this, and you told me you wanted to miss. And this is going to be a fiasco.
Oh, and we're here for it. We are here for it. We are here for every minute of this, because usually, like, trials are not this exciting. And like every time you turn around here, there's another explosion. It's like misery loves company, you know. It's let me know whenever you want me to stop.
You're going to have a good time reading this, because it talked about no self-awareness and tone deaf.
Oh, I can't wait. I'm looking forward. If you want me to stop at any point, just let me know. I'm going to read this to you, my friends, because that's what we do here. We analyze legal documents, and we talk about them, and we read them so that you have a firsthand look at what we're talking about. Because a lot of times people get on shows and they just start talking about it as if everyone's read it, and not everyone has. So the case is the Commonwealth versus Karen Reed, and this is entitled "The Commonwealth's Opposition to Defendant's Post-Trial Motion to Dismiss." Now comes the Commonwealth in opposition to the defendant's post-trial motion to dismiss her indictments for second-degree murder and leaving the scene after causing death, as the defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. Okay. Further, contrary to the defendant's claims throughout jury deliberations, the defendant was given a full opportunity to be heard The jury's communications to the court explicitly indicated an impasse on all charges, and the court carefully considered alternatives before declaring a mistrial. The defendant's unsubstantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. Well, you can see by my facial expressions of the opening paragraph.
Yeah.
On June 9th of 2022, the defendant was indicted by a Norfolk grand jury for second-degree murder in violation of a statute, manslaughter while operating under the influence in violation of another statute, and leaving the scene of personal injury or death in violation of the third statute. On April 16th, 2024, a 10-week jury trial commenced in front of Judge Beverly Canoni. The jury began their deliberations on June 25th, 2024. In addition to the 3 indictments, the jury was instructed to consider 2 lesser included offenses to manslaughter while operating under the influence. 1, involuntary manslaughter. 2, motor vehicle homicide, OUI, liquor, and negligence. The defendant's motion states that the court's decision to declare a mistrial, quote, was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Yet the defendant's motion and supporting affidavits of counsel inexplicably omit the full opportunity that the defendant was given to be heard and the defendant's consent to the mistrial. Beginning on Friday, June 28th, 2024, at approximately 12:15 p.m., the jury sent a note saying, I'm writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. At that time, the court requested argument from the Commonwealth and defendant as to whether the jury had engaged in due and thorough deliberations. The Commonwealth responded that the jury had not had sufficient time to deliberate. And let's see the footnote. Whether the jury had engaged in due and thorough deliberations, the footnote says, the general law, section 234A, section 68C, failure of jury to agree states, if a jury, after due and thorough deliberation, returns to court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent unless they ask from the court some further explanation of the law. It's a little bit confusing.
Yeah.
The Commonwealth responded that the jury had not had sufficient time to deliberate and requested that the jury be instructed to continue their deliberations. On the contrary, Attorney Yannetti argued, we believe that there has been sufficient time. Footnote 2, trial transcripts are not yet available. However, the trial was widely broadcasted across national media. Attorney Yannetti's statements are available for view, and then they cite the link to the NBC Boston testimony. Wouldn't it be funny if they cited to this show and they had you and I like squawking about it?
Well, look at the link they cited to. I mean, that's not a great link for it doesn't matter, but look at the name of the link. Jury says they're unable to reach. Oh, I misread that. Okay. Never mind. No, I misread. I'm bad.
Unable to reach unanimous verdict. Yeah.
No.
And advocated for the jury to be declared deadlocked and provided the 2E Rodriguez instruction. Attorney Yannetti said, quote, the word exhaustive is the word that I think is operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. You know, this is the case where the jury has the legal instructions. They've only really asked one question, which was trying to get a report they were not allowed to get. And I think the message has been received that the evidence is closed and they won't be getting anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the 2E Rodriguez model instruction and go from there.
So this cites, I'm sorry.
No, I would like for you to interrupt me, God.
This is meaningless because this is the first note. And even if they wanted the charge read at that point, even if their position was based upon that note that, we think that they're at an impasse, there was another note that came. And as you'll see, when you get to that Blueford versus Arkansas case, you can change your mind and that means everything. So I'm not sure why their reaction after the first note, in which they did go back and deliberate, would have any bearing on the ultimate issue. I mean, this just seems to me to be language to fill a page.
Well, isn't that what we're doing here? It's like a scratch and sniff motion that he took from another case, and he just crossed out the names and changed them. That's what we used to call them, scratch and sniff motions. Change the date, change the name, change a little bit of the facts, and just here you go, same case law. Hopefully he didn't use ChatGPT, because that would be a problem.
Well,
Sandra Birchmore's attorney did that in the civil case and was sanctioned $2,000. He had ChatGPT write a response to a motion. Yeah, it was bad.
God,
Just happened in February.
That's horrible.
That's not good.
No, Michael Cohen got in trouble. One of his lawyers got in trouble with that in federal court in the Southern District for that.
Oh, recently, where there were like two guys. Yeah. And then they doubled down on that in federal court. That was a crazy case. We should talk about. That's a good topic for a show one day when there's no more Karen Reed to talk about. That's a great.
In 6 years.
Yeah. Crazy. Yeah, we'll be here for 6 years. Exactly. We'll be celebrating birthdays together, Mark. It's going to be great. See Commonwealth v. Rodriguez, Commonwealth v. Toohey. Instruction is for situations where after due deliberation, the jury has expressed that they are in an impasse. And see also Ray v. Commonwealth. The Toohey Rodriguez instruction has a certain sting to it. Commonwealth v. Rollins, a Toohey Rodriguez instruction should not be employed prematurely or indiscriminately. The court ruled that given the length of this trial, the number of exhibits, and complex issues in the case, there had not been due and thorough deliberations, and instructed the jury to continue deliberating. On Monday, oh yeah, that's right. And then they went home for the weekend, remember? Okay, good. On Monday, July 1st at approximately 10:45 a.m., the jury sent another note to the court stating, Judge Cannoni, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implication it holds. End quote. Following receipt of that note, the court again inquired of the Commonwealth and defendant as to whether there had been due and thorough deliberations. The Commonwealth argued that although the jury had been deliberating for approximately 22 hours, given the length of the trial and the number of witnesses, the jury had yet to engage in thorough deliberations. Attorney Yannetti again sought a Toohey Rodriguez instructions, stating that the jury has, quote, come back twice, indicating essentially that they're hopelessly deadlocked. They said they've been over all the evidence. At this time, they say they have fundamental disagreements about what the evidence means. It's a matter of opinion. It's not a matter of lack of understanding. Footnote 3, which says the counsel's argument is available at this link from NBC Boston. The court found that at this point, the jury had engaged in due and thorough deliberations, noting that, quote, this has been an extraordinary jury. The court indicated it had never seen a note like this, reporting to be at an impasse, end quote.
So that's interesting to me. What does that even mean? And why shouldn't that be fleshed out? I mean, this is a judge who's been a practicing lawyer or judge for probably, I don't know, 30, 35, 40 years. I'm guessing. I'm not trying to age her, but she's experienced.
She's in her 60s. We know she's like 63, let's say, maybe.
So let's call it like 35, 40 years, whatever, or 35 years. Had a lot of experience and has never seen a note like this. Well, what's so special about the note? I mean, that would be kind of interesting to know, and how that factors into any of the next steps that should or should not have been taken.
Right. That it was so well written and well reasoned that she usually gets a note that says, hey, judge, we can't agree. Could you let us go?
I don't know. But I mean, she went out of her way to say that this note is, remarkable for some reason. And why?
Yes. Excellent point. At approximately 11 a.m. on July 1st, 2024, the jury was advised of the full Toohey Rodriguez instruction, including that it was the jury's duty to decide this case if you can do so conscientiously, and that there's no reason to believe another jury would be more competent to decide this case. We were there for it. We heard it. On July 1st, 2024, at approximately 2:30 p.m., the jury sent a final note to the court stating, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. End quote. Following receipt of that note, the court discharged the jury and declared a mistrial. Comments on a lot of people have sent me emails and comments about, because they said charges in here, elements of the charges, that means that there's no way that they came to a consensus on an acquittal of charges 1 and 3.
I don't know.
I
There
say,
were two
go ahead.
lesser included offenses in charge
Right.
2, which is the one that they were literally hung on. How do you know that they weren't stuck on different versions of that particular count? I don't think you can determine one way or the other. And of course, the only way that you're ever going to know is to hear from jurors.
Absolutely what common sense tells us as lawyers, being analytical minds, but there are a lot of people out there spewing a lot of nonsense that because they said elements of the charges, that means there's no way they reached a unanimous decision on 1 and 3. You and I both disagree.
Again, there were really 5 charges. There were 3 indicted counts, but there were lessers on, ironically, the count that hung,
Yep.
which I'm not sure this helps the DA at all. I mean, I'm not saying the language hurts them. I think their argument is a fair one, their interpretation of it, the plural. But I think that the obvious counterpoint by the defense is about the point you and I just made is equally as compelling on that point. I wouldn't read into this too much.
Thanks. Thanks for validating me, as you always do. The
Absolutely.
representations made in counsel's affidavits have no legal bearing on the mistrial, as the jury did not reach any verdicts, partial or otherwise. That's not what the affidavits say. I mean, that's not what the two jurors told Alan Jackson.
No, and it's fascinating because on the one hand, they're saying it's all hearsay and conjecture, but I mean, I don't want to jump ahead, but later on, you're going to see you're not even allowed to talk to jurors about this issue. So what is it? I mean, you're going to blame them for not having the right information, or are you blaming them for they got information they're not entitled to, or somewhere in the middle? I mean, this really sounds like they just don't want the truth to be heard, and they have zero concern that they could theoretically be retrying a woman for murder who got acquitted of murder, and they don't even care.
Right.
They,
Well, I
they
mean,
literally don't care.
this entire trial was not about finding the truth. There
No,
was no truth finding going on here
no,
at all
no.
during, from the second 911 was called.
Right.
Citing a juvenile, the Commonwealth.
So I read that case the other
Mhm.
day. It's interesting. It sounds at first blush to be kind of on point, but there are some sort of differences. So, in that case, they said that they were hung and it was a juvenile charged with murder. And they found later on in the jury room slips that checked off not guilty. And of course, the lawyer eventually found out, and we're talking months later, and wanted an acquittal entered on the not guilty count, and wanted alternatively bring the jurors in. And the court basically said, well, we don't know if anybody changed their mind. Those slips were never published. We don't know. And we're not going to let you 6 months later haul in a jury. So, number one, in this case, the jurors reached out to the lawyers within 24 hours. And within
Mhm.
a week or less, 4 of them came forward and said, we're 12 out of 12. In that other case, none of the jurors came forward. So that in and of itself is different. And of course, the timeline, this is still fresh. This is still new. And you have very disturbing allegations also where the jurors are saying our deliberations were completed. There was no concern about changing our mind. When she declared a mistrial, we were done deliberating. So
Mhm.
there's no insecurity about whether that's, what if another juror had changed their mind? That's why you do a retrial. They're all saying we agreed 12 out of 12, not guilty. And there's no suggestion that they were going to go back. And in fact, they never did go back and reconsider. So it's true that, the verdict has to be published. But in this case, it appears the jurors are suggesting we didn't know how to do that and we were confused and we got all screwed up with the instructions and the slips. And I mean, is everybody comfortable with the fact that, oh, well, sucks to be them? They don't know what they were doing. And, maybe they meant to do it. But since we don't know, I'll tell you what we'll do. We'll just call it a hung jury and we'll tee it up again in 6 months and retry her for murder. And everybody okay with that? I mean, maybe in Stalinist Soviet Union, maybe, but in America in 2024, that's kind of like not a thing.
You would think. Let's
Yeah.
hope.
So-
Massachusetts has been like the upside down.
So this case is interesting, but it's a little bit different.
It was like they found scrap paper in the jury room,
They
basically.
found scrap paper and the court's like, I'm not, they said they were going to be hung. I'm not asking questions. I'm not crediting slips, that sort of thing. But again, in the case you're dealing with here, you have jurors reaching out within 24 hours saying there's a miscarriage of justice and we're 12 out of 12. And we want to be, we're happy to share that. And to not even flesh that out. I mean,
somebody went so far as to say they were on the bus and they were discussing it on the bus. Like, is anybody going to ever know that she's acquitted on counts 1 and 3?
Listen, I said this earlier to someone else. I don't even know why. If this DA had any sense of fairness, dignity, common sense, self-awareness, whatever else, why not submit a response and say the following? We reserve our right to argue the defense waived. Okay. In other words, we're not, by arguing the merits, you have to promise, let us, after a hearing, argue if we feel it's appropriate that the defense should have objected. But in the interest of justice, due to a possible miscarriage of justice, and given everything going on with this case, these are very serious allegations. We don't object to fleshing this out and taking evidence to determine if this even has any merit. They don't have to agree that it does. But what is the harm in just saying, let's hear what this is, and then make your arguments, argue that they waived it? And the answer is because they don't care. They have no problem with what the jury did or didn't do. And if they can retry her, they want to do that. And the irony is the PR that they're getting killed on is going to be much worse when this gets denied. And the jurors are going to start screaming and yelling, saying, I can't believe nobody wants to hear this. I don't want this on my conscience. We acquitted her, and here's what happened, and here's why we never checked the box. I mean, how do you not want to hear from the foreman and say, why didn't you check the box?
So you're jumping ahead so far as to say that you think this is going to be denied.
Yeah, I mean,
because you said when it's denied.
Yeah.
All right, let's keep reading.
Yeah. I mean, it's Chinatown. Of course it's going to be denied.
It's Chinatown. It's Chinatown in Dedham. All right, so a Juvenile v. Commonwealth, the case that you just described to us, they cite for the proposition that verdicts must be reported in open court. Quote, the only verdict can be received and regarded as a complete and valid verdict of the jury upon which a judgment can be rendered is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered of record in the presence and under the sanction of the court. Lawrence V. Stearns.
But they're burying the lead on that quote, which is, I mean, I think everyone agrees that's what's supposed to happen. Mm-hmm. But what if there is legitimately a non-meeting of the minds where the jurors meant to do that, and through whatever reason, that's no fault of the defendant or anything like that, it didn't happen for a reason? How do you cite this case from, 40 years ago and say that this stands for we don't even want to listen to you because we don't care what the miscarriage of justice might have been. It wasn't read in court, therefore it didn't happen. How do you not peel the onion back a little bit and use your brain as a lawyer, a minister of justice? You wear the white hat as a prosecutor and say, let's focus on substance more than form. You may have a woman who got acquitted that we're about to retry, and they don't care.
Because they don't want to shine a light on anything. Do you think he's got marching orders from Marcy?
Of course. Listen, this is Morrissey is the DA. This is filed. This is on him for
He's
sure.
the man behind the curtain.
Yep.
The Wizard of Oz. That's him.
Yep. No, of course he should be blamed for this. Everything they do ultimately is his fault.
There's no interest in finding the truth here, and it's egregious and contumacious, I would submit to you. Let's say these are some more cases. Commonwealth v. Tobin, the verdict which determines the rights of the parties and is admitted of record and upon which judgment is rendered is the verdict from the lips of the foreman in open court. Okay, but they didn't understand that somebody wasn't going to ask them about the other counts.
I think any sane person would generally agree with that, but not every prior case law, including one, by the way, that I will note is from 1878. Now, let me give you a little, if you write a lot of appellate briefs, which I do, and other briefs, and I'm sure you did, when you cite cases, including one from 1831 and 1878, now I know this is not the most popular issue to be litigated, but just because something was the law in 1831 doesn't make it proper in 2024. In 1954, segregation was the law of the land. That didn't make it right. The law changes, okay? And what you have here is a very, very unique circumstance. And to cite 1831 and 1878 to say that if it wasn't read in court, that's the be all end all, you're not even interested to know why. If 12 out of 12 people say, my God, we didn't know.
1878.
And 1831.
I mean, we could say there's no cases on point, in which case perhaps we need to do what is the just and fair thing under the U.S. Constitution for the defendant.
I guess
make the case law, Judge. Make it.
Right? They couldn't find Marbury versus Madison to throw into this. My God.
This says here a juvenile case that you talked about before. No error in the judge's refusal to accept the not guilty verdict slips found in deliberation room after the jury was discharged, where those slips were in contradiction of the jury's report to the judge in open court that they were deadlocked. Well, somebody was doodling on a verdict slip and put it in the garbage pan, probably with an inkwell, with a pen and ink. I don't know how old that case was.
But the other thing was this too, not to beat this to
1984.
Death. They didn't know in that case when those slips were filled out. In other words, you could change. They could have thrown it on the floor because, okay, forget it. Somebody changed their mind. We're deliberating. The key here is when the jury sent their last note and the judge declared a mistrial, they were done. There was no more deliberation. And every single juror, apparently, admittedly hearsay for now, is saying that to a man and woman, we were done with murder, acquitted, not guilty. That's that. So, I mean, they're not being honest to the issues. I mean, they're focusing on form over substance, and to literally have such disregard for the double jeopardy clause and the Bill of Rights and a defendant's, fundamental constitutional rights to be not tried twice for the same crime, which I would suggest that, every 10-year-old is familiar with that concept. What's the harm in fleshing this out? They may very well win after a hearing. They could be right. There may very well be somebody who says something that helps them, but they don't even want this to be heard. They don't want anybody to know. And the people that they're punking are the jurors primarily. And I think that's not going to sit well with them, because when they find out that she can be retried for murder, when they know, according to the affirmations we've seen, that they've acquitted her, they're going to be looking for people to talk to.
That's when the interviews will start.
Absolutely. Because they're not going to keep it, not going to be on their conscience. Okay. If she gets retried and you're one of those jurors, you're going to want everyone to know it ain't our fault. We acquitted her. Judge doesn't care. DA doesn't care. Nobody cares other than the defense lawyers, and shame on all of them.
And they're not going to be interviewed by that softie who interviewed Paul O'Keefe for the local news channel. No. They're going to the Today Show. They're going to Good Morning America. They're going to 60 Minutes. They're going to, the big dogs.
Yeah.
So, that's going to play a lot worse for the Commonwealth.
And the key is this. They're not going to just want to say that, well, we acquitted her. They're going to want to clean their conscience, and they don't want to be criticized. They're going to explain in excruciating detail what happened, so they don't get blamed if she gets retried. I mean, they're going to give you the whole sordid story, and whether that includes the bus ride, the discussion with the judge, why they didn't check the box on the sheet, if that's what really happened, whatever it is. I mean, the lack of self-awareness of the zombie prosecutors is unbelievable. They're just going to make it worse.
You're a zombie. I'm a zombie. We're the zombies, Mark. Come on now.
Well, they're going to make this already mess a lot worse because the jurors are going to come after them, I think. I really do.
Yeah, let's keep going because we're only on page 5, and then we have a whole bunch of time to talk. The hearsay comments and juror statements about what happened are legally irrelevant as the jury failed to reach any verdicts. And then they're quoting Blueford v. Arkansas, which is a case that a lot of people are talking about. So let me read what Adam Lally says about Blueford, and then you can tell us what you think.
We had a discussion the other day. I came after Coffindaffer for her attempt to use this the other day.
Point, counterpoint. Here's what Lally says. In Blueford, the jury sent a note to the court indicating they were hopelessly deadlocked and that the court asked the foreperson to disclose the jury's votes on the 3 charges: first-degree murder, manslaughter, and negligent homicide. The foreperson reported the jury unanimously agreed the defendant was not guilty of murder, but were deadlocked on manslaughter and had not voted on negligent homicide. The court gave the jury an Allen instruction, akin to the Tui Rodriguez instruction, that emphasized the importance of reaching a verdict and instructed the jury to continue deliberations. See Allen v. the United States. After a half hour, the jury reported that they had not reached a verdict and a mistrial was declared. I'll go on to say the U.S. Supreme Court rebuffed the defendant's claim that the jury acquitted him of murder, as the foreperson's report was not a final verdict because the jury had continued to deliberate and, more importantly, gave no indication that they were still unanimous on the murder charge.
I don't know why they think this helps. It doesn't help. And they're burying the lead. I mean, the whole point of the Supreme Court in this case was that, and look, it was from Arkansas, and they do things a little differently. They did
different, more differently than Norfolk County?
Pretty bad. I mean, they polled the jury, and the jury originally said, yeah, we reached a not guilty verdict on murder, but we were hung on other counts. And the judge was like, y'all get back in there and deliberate. And they did. And then they came back and said, we have a hung jury on, without specifying. And the Supreme Court very clearly said that because they deliberated after they had previously said that they were going to acquit, that means that was a non-final determination because somebody might have changed their mind. And Lally, or McLaughlin, I guess, probably mentions it in here, but they completely bury the lead. In Karen Reed's case, they didn't deliberate any further. They had a final outcome. They were dismissed. And the jurors are contacting the defense lawyers and saying, we had a final verdict of acquittal. Blueford is totally different. It's completely distinguishable because the whole premise of the holding was that after they initially said that they were going to acquit, they went back and deliberated farther, came back and said there was a hung jury. How do we know that somebody didn't change their mind on the murder charge? This case has nothing at all to do with Karen Reed's case. It's totally distinguishable, and anybody waving this one around is not a lawyer because it sounds interesting. It is interesting, but the whole basis for the court's holding was, but they deliberated further. So how do you know? I can't credit a jury saying she's not guilty, but then they get forced back to deliberate, and then a mistrial is declared. Well, what if somebody changed their mind? You don't know. That's not here. Every juror, apparently, according to these affirmations, is saying we had a final verdict of acquittal on those 2 counts. And most importantly, after they were brought in front of the court and wanted to say that and didn't know, they never went back and deliberated and theoretically could have changed their mind. So this Blueford case is totally distinguishable.
Thank you for that, because everyone on the internet seems to think that's the case, and that's why they should win.
If you're watching Coffindaffer, delete your tweet. It's wrong. You don't know what you're talking about. Be better.
I could say so much more, but I'm just going to leave it there. I'm going to let you say it. Thank you. And so that, my friends, is the counterpoint to Blueford.
And they point that out. So I don't know why, but I'm not sure why, because of course, in addition to burying the lead, they just leave out, well, first of all, they never talk about the Jackson and Yannetti affirmations because, most real lawyers, and again, I'm going back to like appellate brief practice and or any brief, you have to confront the other side's arguments, even if it's unpleasant, even if it's not what you
Of
want.
course.
You can't bury your head in the sand and ignore them. They do. They just say it's irrelevant, it's meaningless, so you shouldn't consider them. But when you start citing Blueford as controlling precedent, you're being intellectually dishonest if you don't at least say, but yeah, according to Jackson and Yannetti, these jurors were done deliberating. They had a final verdict of acquittal, and they have 12 people apparently prepared to say that. That's kind of a difference.
So they're not even going to address those affidavits in this
No,
motion?
they're
In this
hearsay,
response?
irrelevant, doesn't matter. No, who cares? What's for dinner? That's all they care about.
Deep breaths.
Yeah.
All right. Again, in talking about Blueford, here goes Lally or McLaughlin or whoever wrote this. The U.S. Supreme Court rebuffed the defendant's claim that the jury acquitted him of murder. The four-persons report was not a final verdict because the jury had continued to deliberate and, more importantly, gave no indication they were still unanimous on the murder charge. The U.S. Supreme Court emphasized that when jurors engage in discussions about the circumstances of the crime, it often causes one to rethink their stance on a greater offense and revisit a prior vote.
How is this helping them?
I can't see that it is.
I mean, I don't. I
So
get
let's flesh it out as to all the more reasons why it doesn't control here. The very object, I mean, that's what they're doing. The very object of the jury system, after all, is to secure unanimity by a comparison of views and by arguments among the jurors themselves. Single juror's change of mind is all it takes to require the jury to reconsider a greater offense.
So that's when like these prosecutors need a TED talk again, which is everyone agrees that jurors can change their mind, but you're being intellectually dishonest when you don't even inform the court that the affirmations that have been submitted are conclusive. Look, they're hearsay, and that's why the proper thing here is to develop more evidence. They have reached a threshold of we ought to explore this. And the fact that they won't even acknowledge that all of these jurors are saying, we didn't change our mind. We are unanimous, but we never had a chance to say it because the judge said mistrial and threw us out of there. How do you make this argument, cite this precedent, and not note the huge distinction in the case at hand?
It's poor legal writing. That's why. That's how.
Yeah.
Like you're not arguing that what they said is wrong. You're just arguing something different.
And you know what?
And citing cases that aren't controlling or don't
If
really
they
apply or can be easily distinguished.
And you know what? They could do a hearing, okay? And you could call in the jurors.
Inquire.
You could turn off the cameras, no names, do it in a way that none of the jurors are publicized. And you know what? At that point, Adam Lally can demonstrate his very skilled cross-examination and ask the juror each one. And you know what? Bring in all 12. You only need one.
Oh yeah, you need them all.
One. Ask the 12 jurors, were you done? Did you want to deliberate further? Were you final? Were you all set? And if one of them says, I don't know, then you win. Good for you. And, then Blueford maybe helps. But that's not the allegations in the Jackson and Yannetti affirmations.
The note clearly said, we're done. We're done. And they were wondering when they were going to be asked if they had acquitted on any of the charges. And they say they were just rushed out of there.
Yeah.
And they were confused.
And
because in her instructions, which I replayed the other night, she said, don't come back to me until all the forms are filled out.
Right. And the DA's position is, you want sushi or Chinese. Who cares? I mean, seriously, it's all they would have to do. It's so frustrating because I mean, all they would have to do is say, we reserve our right. Hang on one second. What? No. Reserve our right to argue that they waived, right? And at the same token, say, these are serious allegations that in the interest of justice, we ought to flesh out. And it doesn't mean we agree
further
with it.
inquiry.
That's right. And we are fully prepared to examine and argue against with a straight face. But their attitude is like they want it denied, and they don't even want you to know what's in those affirmations. They don't want to hear it. And they have a legal right to argue that way. But how tone deaf can you be? I mean, when you have 12 out of 12 saying, I swear to God, we tried to acquit her. We did, in fact, acquit her, and nobody wanted to know. And most importantly, Your Honor, we were confused. And they're arguing, you're going to get to this later, that you shouldn't even allow the defense to try to generate evidence to explain this, which I have to say is absolutely disgraceful. To do not even allow the jurors to present an explanation as to what. Doesn't mean you have to agree with it, but to argue that, my God, I swear to God, we really did acquit her, and here's how you know. And the DA says, no, no, no backsies. You didn't say it on the record because there was a case in 1878 that said you didn't say the magic words, not guilty in court, dismissed, go home, nothing to see here.
And it's not even like this case is over. Okay. We're in purgatory right now. So think about it. If there's acquittals on counts 1 and 3, that's less work for Lally, because now when he retries it, he's only retrying that one thing.
It's funny you say that, because the other example of how tone deaf and just dim I think these people are, they could have come in and said, you know what, Judge, although we don't agree with the merits of this motion, we're going to dismiss the murder charge. So it's not even a legal controversy. The court need not address it, which would be a smart thing for them going forward anyway. Now, they'd still have to deal with the third count if they want to pursue that. So it's not like the issue would go away. But the reality is this is a murder case. The public scandal here is that you're going to retry a woman for murder who may have been acquitted. Although it would be bad if it was a leaving the scene of the accident case, she's facing life in prison. I mean, if you understand how media works, that's the focus here. That's the lead. It's a murder case. Yeah. And if they kind of got rid of that, this would be a lesser thing. And they would look, hold your breath, dare I say it, almost reasonable.
Even heroic, I would submit. I mean, I'm not going to go that far, but it would be like, okay, we really are interested in justice here. But they're not interested in justice because remember, they've been frying innocent people since 1692 or whenever the Salem witch trials were.
Right. They no, what they do is defense motion, we oppose. Like defense bad, prosecutor good. I mean, they're like, it's almost like Neanderthal brain that they're trained, no matter what they say, we oppose. And there's no original thought, there's no skill. There's no thought about what's right, what's wrong. And they're so predisposed to think that, the lawyers are slick. She's a killer and she's abusing the process.
Yeah. I mean, look at her outfits. Look at her facial expressions.
Yeah, no, clearly. I mean, she's a terrible person who, is able to afford top shelf representation, and they're filing these silly motions and they're bringing in another heavy hitter to argue this motion. And our response is, they're not even entitled to address a pretty good faith argument that warrants further exploration. It doesn't mean you have to grant the motion, but why wouldn't you hear it?
Of course. Why wouldn't you want to inquire further so that justice could truly be done? And in the interest of, since you mentioned the mounting legal fees, which are going to cost who knows how much, I want to take a time to mention Kelly Reed's fundraiser. Kelly Reed is Karen's cousin. And there is a fundraiser that opened today. She's selling popcorn, I think, and everyone says it's the most amazing popcorn ever. If the mods could drop the link in the chat, please, that would be amazing. If you would like to donate to the defense fund and also get yourself some great snacks, that would be really, really appreciated, because this is going to be a second huge expense for Karen Reed, and Karen Reed could be any one of us, my friends, any one of us. Moving on. It must be recognized that as a practical matter, that the jury votes on included offenses may be the result of temporary compromise in an effort to reach unanimity. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of final adjudication should not be given to any jury action that is not returned in a final verdict.
It's another empty paragraph ignoring the issue in a general sense. Yes, but again, the issue here is they are saying we did acquit, we contacted the lawyers, and we didn't know what to do and how to convey that, and by the time we wanted to do that, we were thrown out of there. This is not buyer's remorse. This is not something cooked up by lawyers who approached jurors and, tried to get them to say what they want. They were called by jurors within 24 to 48 hours saying, you need to know this. This is bad. These cases are not on point.
I'm going to play devil's advocate here because I've heard a lot of this counterpoint. So here's my devil's advocacy argument for the other side. But, the other jurors may come out and say that that was just a compromise verdict, that they agreed that they would acquit on the murder charge if we would convict on the manslaughter charge. Let's say you.
Well, if their position,
how are we going to know?
Well, you're not going to know. And I mean, look, if that comes out and somebody says, well, that's a fair argument that shows that maybe they weren't done, then touche. But aren't we all better off knowing that? Isn't Karen Reed better off? Isn't the DA better off not creating litigation down the line? Everyone.
And the public perception.
Absolutely. And moreover, if they all say, though, whether we were compromising or not, but that was my final be all end all judgment, then I would say it doesn't matter. If they were to say, but we were still kicking back and forth, well, then okay, then I would say, you know what, that sounds like a hung jury. I mean, if one of the jurors came in and said, well, we were just trading horses and I wasn't sure, fine, there's your answer. But shouldn't we all know that?
Mm-hmm. There needs to be
the DA to have the public know that and say, get off my back.
Get off my back. Breaking news. Turtle Boy won his Rule 17 motion. All of those Tully texts can only help Karen. Honestly, I don't know what that's about, but I guess he made a Rule 17 motion in his case to get all texts with Tully between Tully and someone else.
Yeah.
So those texts are going to come out. Who knows if that's interesting.
Yep.
Wow. Okay. Interesting. We'll see what happens there. Okay. The jury's notes were unambiguous. This is going back to Lally speaking now. The jury's notes were unambiguous that the jurors were deeply divided by fundamental differences in our opinions and state of mind that resulted in a starkly divided jury as to the charges. Emphasis on plural. Oh, see, he did do that. The jury consistently indicated that their impasse was not due to a lack of understanding of the law or the charges, but a profound divergence in deeply held convictions, ultimately leading to a point where consensus is unattainable. The jury's notes did not indicate agreement or acquittal on any of the charges. Rather, it was evident that the jury was unable to agree on any charges due to their sincere adherence to their individual principles and moral convictions.
Pretty self-serving and conclusory. I mean, it's certainly a fair argument, but to write it as finite fact is, I think, taking liberties with what the evidence is. As far as the charge is plural, again, the hung count had multiple charges. I mean, that's plural, and it's true that they didn't indicate agreement or acquittal on any of the charges in their note. But what does that mean? That does not necessarily follow that that's proof that they were unable to agree on any charges, because that's not what they're saying.
Right. And she told them explicitly, once you come to a complete agreement, a unanimous decision, come back. It didn't say, they understood that to mean on all of the charges is what they're saying now.
Yeah.
Lally says, contrary to representations made in the defendant's motion and supporting affidavits, the defendant advocated for and consented to a mistrial as she had adequate opportunities to object and instead remained silent, which removes any double jeopardy bar to retrial. Citing Commonwealth v. Fatsaya from 1996, consent to a mistrial may be inferred from silence where a defendant had the opportunity to object and failed to do so, citing Daniels v. Commonwealth, where defense counsel told judge he believed the jury was at an impasse in deliberations and had no objection to the judge declaring a mistrial. Such consent removed any double jeopardy bar to retrial. Pellegrin versus Commonwealth, despite having an adequate opportunity to object, defense counsel remained silent, proper to infer from counsel's conduct that the defendant consented to the mistrial. See Commonwealth v. Curtis, I know you want to talk. The manifest necessity test has no application in situations where, as here, the defendant requested or effectively consented to the mistrial.
So
Take it away.
now, first of all, you're assuming that these string cites are accurate. No one's read these cases, so you don't even know the facts, but let's at least assume they didn't willingly, butcher the string cites, where he says consent to a mistrial may be inferred, not must be, maybe.
Mhm.
Okay. The next one is a little more stronger, where defense counsel told judge he believed jury was at an impasse and had no objection. Such consent removed any double jeopardy. Okay. The next one says it was proper to infer, again, implying maybe, maybe not.
Mhm.
The last one, where the defendant did not request a mistrial, but they're alleging effectively consented. Again, that's mushy. And
Silence as acceptance.
right. But again, is this form over substance or substance over form? I mean, do you really want to deny finding out whether she was actually acquitted, because you're splitting hairs on whether, when Yannetti said you should read the Tui Rodriguez charge, that in essence was his time to complain and he didn't? And when you came out and, remember, they didn't show the note to the defense. They didn't ask the defense, how do you want us to do this? How do you want to proceed? She just ended up doing it. She just declared the mistrial. I mean, you really want to fall back on that and deny a hearing or fleshing this out based on what the allegations are? That seems to me to be putting form over substance. And I think a constitutional right as important as this ought to trump splitting hairs on what are essentially statutory issues here. And by the way, what are they trying to do? Are they trying to foment dissent here? Are they trying to argue that, are they trying to make it sound like your lawyers screwed up, Karen? Your lawyers screwed up, blame them. That's not going to happen, obviously. But is part of this trying to create tension? I don't know. But that's not going to happen. They're all on the same page. But to blame the lawyers in these circumstances, given what's going on here, seems to me it's almost, if anything, like, when you see in appeals that we're going to reach this in the interest of justice type of thing, to just deny it on, well, you didn't say anything. That's not going to sit well with a lot of people.
Well, since you didn't handle the pretrial motions, I'm going to share this with you. In one of his motions, Lally asked that the judge bring Karen in and read her rights to effective assistance of counsel and have her waive that right to appeal, because in Lally's opinion, whatever the defense attorneys were doing at that time, and I can't remember what the exact issue was, she should be brought in and waive her right to effective counsel. I've never seen anything like it before. I made a huge deal of it pre-trial. I just can't remember which motion that was in, but it was bizarre that they asked for that kind of relief. It was crazy.
Yeah, that's kind of gross, because these guys clearly don't know what they're doing, but at least the ever-present protector of constitutional rights, Adam Lally, was on the case.
Yes, he was. And the judge has reminded us throughout pretrial proceedings and throughout this trial, as you know, it is my right to do this, that, and the other. As you know, I will teach the jury the law. She's teaching them the law. Now, she's not instructing them. She's teaching them the law. As you know, I am well within my rights here. And she did a huge spiel when she denied the motion to recuse herself. And so she has said repeatedly, and if I'm defense counsel, I'm spitting that back at her. Like, here's where this is what you said. It's well within your rights. You have discretion. You have discretion. You have discretion. You've said that throughout the entire pretrial proceedings and this trial, that it's everything here is up to you. Like, this is your domain, judge. So you have discretion here. These cases don't control. Let's really look for justice.
Yeah. And of course, the interesting thing is, I mean, are they going to try to throw her off, arguing that not only should there be a hearing, but you're a material witness and therefore you shouldn't even rule on this? I mean, because don't forget, one of the factual issues here is what happened in that meeting. And if you allow a potential witness in that meeting who obviously does not want to testify to make a decision on whether I'm going to hear this motion or not, and force myself to be called or not, I mean, that sounds like a conflict to me.
Just a little bit. But the appearance of impropriety is something that doesn't seem to bother this judge at all, quite frankly, because if you read that motion to recuse, there was a lot of appearances of impropriety. And she had the opportunity to say, look, I don't know the McCabe's. I didn't take any Venmo from Julie Nagel. I don't know these people. But you know what? To avoid the appearance of impropriety, I'm going to step back from this case and let someone else handle it. Just because that's what judges are supposed to do.
That's what they're supposed to
The
do.
appearance of impropriety here. So if we want to avoid the appearance of impropriety during these jury deliberations and the post-verdict motions, it's not even a verdict. So the post-trial motion here, to avoid the appearance of impropriety, we need to talk to these jurors to see what really happened.
Yep.
Because the defendant's entitled to a fair trial and double jeopardy rights and all such as that.
Are you suggesting it's not a fair trial if you get acquitted for murder and retried for murder?
Yeah, maybe. I mean, what do you think?
Seems slightly unfair and un-American, I would suggest.
Due process. I mean, there's a lot of them.
Yeah.
During her full opportunities to be heard on June 28th and July 1st, at no time did any of the defendants' three counsels, is that even a word? Three counsels?
That's strange writing. Yeah.
I should say three counsel. All right. At no time did any of the defendants' three counsels request inquiry as to what charge or charges the jury was deadlocked on. Rather, the defendant was quick to request a Tui Rodriguez instruction at first opportunity, indicating a belief based on the clear and obvious language of the jury's notes that, as stated by Attorney Yannetti, the jury was hopelessly deadlocked and had exhausted all manner of compromise and was engaged in fundamental disagreements of what the evidence means. It's a matter of opinion. It's not a matter of understanding. See Ray v. Commonwealth. Counsel's request for a Tui Rodriguez instruction permits the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. See also Commonwealth v. Perea. The timing of a Tui Rodriguez charge is committed to the discretion of the trial judge. Once a Tui Rodriguez instruction is given, the jury could not be sent out again to continue deliberations without their consent. Furthermore, following the discharge of the jury, the court engaged the Commonwealth and defendant in discussions about choosing a status date for rescheduling a trial or scheduling a retrial. At no time during that hearing did the defendant object or indicate displeasure with the mistrial.
Okay. I mean, I'm not sure what that means.
I mean, people need to also understand that when attorneys cite cases in their motions or responses or briefs, they cherry pick the one sentence that benefits them the most.
Yeah.
So if you go back and read these entire cases, this one sentence may have been stated somewhere in the case, but then it may have said, but in this case, blah, 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 right?
Yeah.
People don't understand that.
I don't know why asking for the charge the first time has any bearing on a mistrial. I mean, what matters is what happened at the end. And at the end, you know, she gave them the charge. They came back saying they were deadlocked, and there was no discussion with the lawyers about what are we going to do? How do you want me to respond to this note? She called them out and said, I'm declaring a mistrial.
Mm-hmm.
And
Right.
the jury is telling us, again, whether the judge wants to hear it or not, that, well, wait a minute. We didn't know that. If we had known that you were going to like not talk to us, we wanted to tell you something. We had a question. And, you know, it's one thing to criticize the lawyers for they should have done this. They should have done that. What the DA here is effectively doing is criticizing the jury in the same way. I mean, but they don't know. It's actually distasteful, and I think it's going to blow up in their face. They're basically blaming the jury on one hand by saying,
Right.
why didn't you say what you needed
something?
to say? That's right, because they were confused and didn't know.
I bet because every time they asked for something, they asked for the report, the cert report, they were told, you have all the evidence. There's nothing else we can give you.
Right.
Perhaps they didn't feel all warm and fuzzy about asking for further clarification because the judge said, here's the jury instructions, bring them back with you in the room, but I'm going to tell you stuff now, and whatever I tell you is going to be controlling over what's written on the page. So, you know, pay attention, basically.
Yeah.
The mistrial was also supported by a manifest necessity, jury deadlock. See Commonwealth v. Bryan, Thames v. Commonwealth, Oregon v. Kennedy. If you want me to read any more of that, let me know. And a juvenile case that we talked about before.
I mean, again, this is like stating the obvious, but it doesn't peel the onion back. I mean, it's black letter law in every jurisdiction that if there is a mistrial declared after the first trial because of what appears to be a hung jury, that of course you're allowed to retry the case, that there's a finding of a manifest necessity to get past double jeopardy. But again, they're skipping the issue. The defense is arguing there was not a hung jury on every count, that there were actual acquittals, and they're just stating a conclusion. I mean, this is crib language from, like you said, this is a cut and paste job from something else. This has no bearing on this case. This is just in their brief bank about, double jeopardy.
Yes, agreed. I think that Chesna case, which also involved the death of a police officer, resulted in 2 hung juries. So
God.
Interesting. The trial judge is best situated to determine whether the ends of substantial justice cannot be attained without discontinuing the trial. In declaring a mistrial premised upon the judge's belief that the jury is unable to reach a verdict, that decision is treated with great deference, because otherwise there would be a danger that the judge would employ coercive means to break the apparent deadlock. Again, here's some spaghetti.
Yeah,
Would you like another plate of spaghetti?
Yeah, I mean, it skips the confusion, and they didn't know. I mean, they keep talking about the defense didn't do this, and the judge doesn't have to do this, and they keep ignoring the pink elephant in the room, which is the fact that the jury, at least on the evidence that's been presented through lawyer affirmations, is saying we got schnookered. We didn't know what we were supposed to do, and if you had told us what to do, we would have said not guilty. And nobody wants to listen to that.
Right. Nope. Nobody wants to hear it. The court engaged in considerable efforts and sent the jury back to deliberate 2 times following the notes that they were at an impasse. And in addition to finding that the jury had engaged in due and thorough deliberations and providing the Tui Rodriguez instruction, at the request of the defendant and to her satisfaction, during deliberations, the court amended the verdict slips to clearly depict the lesser included offenses and provided the jury a supplemental instruction on how to consider lesser included offenses. See Blueford. The U.S. Supreme Court has never required a trial court, before declaring a mistrial because of a hung jury, to consider any particular means of breaking the impasse, let alone to consider giving the jury new options for a verdict.
I don't know how that helps, because it's kind of the same thing, which is, you could say that we gave you the lesser includeds and you added confusion, but you also said don't check anything off until you're done, like completely, until you reach a verdict. But what happens if you don't reach a verdict? They don't know what to do.
Right. Yes. Agreed.
It's just part of the whole confusion argument. And I'm not sure what this paragraph does one way or the other for them.
I think it's just a whole bunch of let's make this really long so it sounds like it's really good and we have a whole lot of substance here when there's really nothing but fluff. The defendant's claim that the judge should have inquired of the jury holds no merit, as nothing in our case law or in general law 234 section 34 required the judge to nothing required the judge, but isn't it within her discretion, because I'm sure it's well within her rights, as she likes to say, required the judge to make either inquiry whether there was reasonable probability of any unanimous verdicts, or if the jury would consent to further deliberations as a matter of course, and the circumstances before the judge did not necessitate either inquiry. The final note from the foreperson unequivocally stated that the jury were unable to come to a unanimous decision. In other words, that the jury were deadlocked. The note did not suggest, for example, that the jury were merely having trouble making a decision or needed further instructions from the judge. Given the 4 days of deliberations, the jury's indication that they had carefully reviewed all the evidence and that their divergent opinions were premised upon deeply held moral convictions, the court was left with no reasonable alternative other than to declare a mistrial.
See, I'm sorry, that's intellectually dishonest. On the one hand, they say the judge is not required to ask, but may. But then the next thing they say is that the court had no reasonable alternative. He just said it's permissible to do it. But then when she didn't, says there's no other alternative. I mean, that's inconsistent within 2 sentences of each other. I mean, they just said it was discretionary for her to be able to do it or not. And then they're saying she had no reasonable alternative other than to declare a mistrial. She could have asked, and the jury, more importantly, again, they keep, I think they're focused on the wrong people. They didn't know what they were supposed to do, is what they're alleging. So let's hear it, and then go or it won't.
Yes, it's more lally salad. Put some salad emojis in the chat, my members. Lally salad. He's been speaking in salad I made an emoji for that. Lally salad. Oh, further consultation with counsel would not have produced any fruitful alternatives, nor is there a reasonable probability the jury would have consented to deliberate further, particularly when the jury wrote to continue to deliberate would be futile and only serves to force us to compromise these deeply held beliefs. Moreover, whether counsel initiates contact with a discharged juror by first sending notice to the opposing party with the substance of the proposed communication, or if the juror initiates contact with counsel, as alleged in the defendant's motion, counsel may communicate with jurors only about permissible subjects.
Yeah, this is
Massachusetts
offensive.
rule. Okay, so this is Massachusetts rule of professional conduct. This is an ethical rule.
Right. So these
3.5C.
lawyers are violating Massachusetts ethical rules by listening to jurors tell them your client a murder that is about to be retried for murder. So the lawyer should, avert their eyes, hang up the phone and say, never call me again and don't tell me this because I don't want to know.
Well, let's hear their professional rule in Massachusetts. It says permissible subjects include counsel's performance during a trial. Oh, so they can call up and say, hey, you did a really great job, or you did a really sucky job. Extraneous influence on the jury's deliberation, or a juror's bias toward the defendant. Okay, so they're allowed to talk to them about bias, extraneous influence or pressure, people trying to bribe them or whatever, or people sitting across from them in the gallery staring them down like I may have some, I'm watching you. That's permissible under the Massachusetts professional rules. But a juror coming back to them and saying, we acquitted on 2 charges is not permissible for an attorney to listen to on a phone?
Where it gets interesting. And again, it just tells you how short-sighted these people are and how they think the law never evolves. I mean, the whole idea of common law is life changes and there are developments and things happen and case law is developed as a result. It's it's not like the Constitution. The law changes with case law. And it's pretty clear that this Massachusetts rule, I'm assuming, so I shouldn't say it's pretty clear, but I'm assuming was not made in ethical rule, in contemplation of, well, what do we do when half the jury calls the lawyers within 2 days and says, you know what, we acquitted.
Mm-hmm.
And according, to the Norfolk DA's office, what Jackson and Yannetti should have done was slam the phone down and say, I'm sorry, don't tell me about this. I don't want to know because I don't want to, do anything that could violate the ethical rule, as opposed to, I don't know. I don't want to violate my duty of responsibility to my client, which is if she got acquitted to pursue that.
Right. I'm not going to be a zealous advocate for my client, which is the number one thing you're taught in law school, zealous advocacy for your client, zealous representation.
Right.
And here's the thing too. Looking at all of these cases that were from whatever, this most recent one is from 2020. There's one from 2010, but everything else pretty much predates that from the 80s, 90s. Let's just be real here. The reason these jurors came forward is because of social media and because of things like Twitter. These things did not exist, okay, when most of the case law was written. And this would never have been an issue because it never would have been spread like wildfire that the jury was 10-2 to convict on, I think, murder. I think that was the rumor, right?
Yep.
So the first juror that came forward, the actual juror said, I was angry and wanted to correct the record that we actually did acquit on murder and the third charge because of things that they saw on social media. So all of this prior case law does not take into account the ripple effects of social media because it did not exist at that time.
The other thing is,
talk.
The jurors call them and the DA's position is you shouldn't listen because there's this ethical rule which clearly doesn't contemplate this. And you have a lawyer on the other side who is listening to this and is saying, I'm being told that my client may very well have been acquitted. Okay. Now, if you're going to pick a hill to die on in the game of, zealous representation, legal ethics, and good faith basis to do what you're doing, okay, let me tell you what a real lawyer in this situation is going to do. They're not going to hang up the phone when juror after juror is saying your client was acquitted. Okay, because if you do that, you're violating a different legal rule, ethical rule, which is, zealous advocacy for your client. And her due process and double jeopardy rights are a little more important than, an ethical rule that was, I'm not against, obviously ethical rules, you have to follow them, but it doesn't contemplate this. And the reality is, it ought to be adjusted, and maybe it will be after this, because I think your point is a really good one, which is in the era of social media and internet involvement, you learn things that you may never have known. And to ask a lawyer 4 times, apparently, to avoid listening to your client being acquitted, such to the point that there are 12 jurors who will come in and ironically, unanimously say that she's not guilty of 2 of the 3 crimes. And for the DA, who, the temerity of them to, like, point out ethical rules and, rub the nose of opposing counsel and violating ethical rules. I mean, that's just kind of ironic.
It's not the first time. Yeah, it's not the first time they've done it.
No.
Kathy says, why not poll the jury? Don't judges poll the jury? Massachusetts rules are different.
Poll, I don't know that poll is actually the
Not
right
polling.
word.
You can't
Yeah.
say, like, is this your verdict? Is this your verdict?
Right,
Unless there's an
right.
acquittal or a conviction, in which case
I know what she means. She doesn't mean literally poll. I think people just think that's the word. But could she have said, is that on everything? Are there any, do you have anything else you can tell me about any of the counts? And, at that point, if they didn't say anything, then I think you'd say that this is going nowhere if that had happened. But then, of course, they might have said, well, wait a minute. No, we have a verdict. And then you know what would have happened? There would have been argument, and probably right then and there, that same day, she gets acquitted of those 2 counts.
Right. Exactly.
Isn't that more important? Again, the substance over form here.
Isn't that justice?
What is the harm in fleshing this out with further evidence? Do it privately so that the jurors don't have to use their names or anything like that. And then whatever happens, happens. Right? I mean, just let it.
Yeah. Let the chips fall where they may.
And you know what? If it turns out that the jury is credible, 12 out of 12 saying we did acquit her, but we didn't know what to do because of your instructions. Again, I'm not sure the judge should be the one deciding, because now she's the one getting criticized. She should be a witness and is potentially as a conflict if it's her conduct that is potentially being criticized here.
Yes. And I would also submit to you that in the same breath, that they're accusing them of violating ethical rules. What they did not do is say, when they got the phone call, hey, can you come into my office and I'm going to write an affidavit for you to sign, and you'll sign it and I'll submit it with my motion, because they're not allowed to do that in Massachusetts, as we would be allowed to do that in New York, by the way.
Right. And that's another thing that was kind of annoying publicly, was you had all the rabble rousers who are amateur lawyers on Twitter. You know who they are. It's all hearsay. Of course it's all hearsay, because they can't go do what you and I would do in New York, which you'd send an investigator and go sit down with them if they're willing.
Statement. And they would actually have them sign the statement, unlike the Massachusetts State Police and the Canton PD.
They did what they could by getting enough to make a good faith claim. And if you look at their motion carefully, they sought permission to develop further evidence.
Yes.
So
you can't help what a person tells you, but you're not going to hang up the phone when you're zealously representing your client and you're getting information that they may have been acquitted on murder.
No, and their affirmations were very careful. They didn't name anyone. They didn't, he, she. I mean, they went out of their way to be, that we know who they are based upon where they're sitting, but we're not going to say anything.
And I asked them identifying questions so I can make sure that this wasn't a hoax and this wasn't some troll just trying to get me in trouble. And I from where they said they were sitting and what they told me they look like, because it wasn't a FaceTime call, I'm assuming, I was able to ascertain that it really was in fact a juror and not a troll who could be posing as a juror, because that could happen too.
There's another really interesting thing floating out. This was kind of a throwaway comment, I think, in David's affirmation. But there was a discussion where after this happened that there was a text chain amongst the jury.
Yes.
Now, I'm not suggesting that's the most reliable or credible evidence, but my God, I mean, does the court, as part of this process, not want to know who is saying what? Does it undermine what any of these people are saying? Does it corroborate? You still need the testimony. You still need admissible evidence, but God only knows what's contained in that text chain. And at this point, the defense doesn't even have a right to see what it is. I mean, we're okay with that they're just not even allowed to explore the issue on behalf of their client, who, again, may very well have been acquitted.
Mhm.
Or maybe
People
not.
are
You should know.
right. How about if they come in and they say, no, we were not agreed on that. That's it. That's
And
the end of the issue.
end of the
Schedule
issue.
the retrial.
Yep.
Very simple.
Yep. And,
People are good.
I was just going to say, and most prosecutors, look, a lot of prosecutors might note that there are waiver issues. There are things that the defense didn't do. Those aren't frivolous arguments. I mean, they're tone deaf in this context by their failure to even recognize that this is not like the non-disclosure of a marginally relevant piece of evidence that arguably could have led to something. It's not like something unimportant. You're talking jurors on their own within days contacting the lawyers for other people, 4 of them, 33% of the jury at least,
Mhm.
and indicating that all of them would agree that she got acquitted. And in responding to this motion, you can't at least recognize that that's concerning, and you have no interest in knowing why, because in 1831, the Salem witch court trial held that, we dunk witches and that's how the verdict is. I mean, I'm exaggerating, obviously, but they're just so tone deaf. There's a better way they could have answered this and still oppose this.
Do they argue waiver in here? Did we not get to it yet?
I mean, I think they pretty much.
I mean, they kind of glossed over it, but it was
Yeah.
kind of like, because they didn't ask right away, it's waived. But is
I mean,
that
yeah, I mean, I don't look at this as the most, the best written thing, obviously, but I think what they're basically, I'm looking at the conclusion, because the defendant consented to the mistrial, which is, I guess, a roundabout way of saying they waive their right to be heard.
I mean, I would think as a defense attorney, you would run the risk that if you start asking questions like right away, maybe they say, no, we actually convicted on murder. We couldn't agree on
Absolutely.
charge 3. So why would you open up that can of worms?
Right.
On the one hand, right?
Right. And then the DA will say, but that's the risk. And they would probably say that's strategically why they didn't ask. I mean, whatever. It's a fair argument, but to me, they're ignoring the real pink elephant in the room, which is that the jurors are banging on the door right away on their own, saying, we got schnookered. This is no joke. Like, we're not trying to become part of the story. I mean, the one guy said, I mean, I'm willing to testify, but only if I'm held private. I mean, he's not looking to make his name known or her name known, depending on who it is. They're legitimately concerned. And you would like to think that they ought to be heard, and it goes wherever it goes.
Right, but we can't just ignore it. We can't just ignore it in the interest of justice. So let's keep going with this.
When you're dealing with an issue like this, I would be really hesitant to focus on a waiver argument. Again, if it's a piece of evidence that was not disclosed, that arguably, I think a judge might say, but I mean, you're talking about the most fundamental of fundamental constitutional rights, being tried twice for murder.
Mhm.
That ought to get you bothered.
Bet John Adams has something to say about that. And I bet we could find it if we looked hard enough, because everybody's quoting John Adams throughout the course of this trial.
Right.
Lally says, rather, what the defendant's motion is entirely premised upon and what is expressly prohibited inquiry is that of the jury's deliberative processes and the substance of the jury's deliberation. Oh, so now he's saying you violated ethical rules by talking about their deliberations. Mm-hmm. They volunteered this information. They didn't go knocking on doors, by the way, like they did in the Murdoch trial. They went knocking on doors, those defense attorneys, after that was over. And they said a lot of people wouldn't even open their doors to them. So, interesting.
Yeah. And even when you look at the cases and they're talking about the secrecy of jury deliberations and not intimidating jurors, I mean, everybody agrees with that. But again, they're burying the lead. The jury obviously doesn't, because they're contacting the lawyers telling them.
Right. It's the jury coming to them.
Right.
Because they want justice for the defendant.
at least
Well,
4.
2 directly and 2 through intermediaries. Let's be
Right.
fair.
Right.
The
No, that's
intermediaries are like double hearsay, right?
yep.
Double.
Yep.
But in any event, it deserves further inquiry
Clearly.
because they couldn't say, okay, tell me who the juror is because I'll reach out to the juror myself. Like that's how these people came to them. That's
I
what
mean, the
they got to take what
reality
they're
is,
given.
it's funny because, I mean, the defense is playing chess and the DA is playing checkers. They've already completely punked the DA because the whole world knows that she should have been acquitted on 2 of these 3 counts, and it's just going to be more pressure. They look stupid, and they took the cheese. I mean, by making the argument that they're making, which is exactly what we predicted they would do, they just dived headfirst into the worst argument they could make. They could at least pretend that her right to double jeopardy is concerning.
Right. They could have consented to further inquiry. We don't we don't agree,
Right.
but and there may be a waiver of this, but why don't we'll consent to a hearing,
That's what I would.
held either in camera or, just
I
like in chambers or like no cameras, but Judge, we don't even need to ask the questions. You can ask the questions.
I would have said to the judge, if I were them, if you're really gonna not agree to this, to say, as long as you allow us not to waive our arguments that the defense waived,
Mhm.
but given the seriousness and of the allegations, that putting all arguments aside that we reserve the right to make at the end of a hearing, we believe it is in the interest of justice and with everything else going on here to at least hear what's going on here.
Yes, absolutely. 100%. All right, let's see. They're citing Commonwealth v. Moore, which stands for the secrecy of jury deliberations has served as a bedrock of our bedrock. It's like Flintstone time. As a bedrock of our judicial system, an inquiry into the jury's deliberative process would intrude improperly into the jury's function. The common law principle that it's essential to the freedom and independence of jury deliberations that their discussions in the jury room should be kept secret and inviolable was not, and argue could not be overruled by the 2015 adoption of Rule 3.5C. Oh, that's going back to the rules of professional responsibility. It is improper for counsel to inquire with jurors or through intermediaries the individual or collective thought processes of the jury, the reasons for their decision, or the substance of their deliberation. That's not what they're doing here. They're talking about acquittal. They didn't say, here's how we came to that decision. This is why we thought this. They just said, we acquitted on 1 and 3. We were unanimous. That's it. Massachusetts continues to adhere to common law principles, barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Similarly, it would be improper for the court to inquire through affidavits or an evidentiary hearing the substance of the jury's deliberations. If, after communicating with a juror, an attorney wishes to secure an affidavit from the jurors, any such affidavit must focus on extraneous influences and not the substance of the jury's deliberations or the individual or collective thought processes of the juror or the jury as a whole. Citing Cassidy. Go on.
Yeah, but I'm just going to say again, I mean, how do you not account for a situation like this? I don't think it was contemplated when that case was cited. But do you really think that if there was overwhelming proof, like play this out, suppose you could look in the future and there's overwhelming proof that this jury acquitted her. Are you going to say, well, we can't deal with that because of Cassidy? Because that's not a topic that's appropriate. I mean, that just doesn't make any sense when you're dealing with something as important as this.
Yeah. The SJC has instructed that whenever a judge asks individual jurors about the possibility of extraneous influences on jury deliberations, whether of jurors who are still sitting as such or jurors who have been discharged, the purpose of the individual voir dire is not to delve into the jury's deliberations. There should not be an inquiry into the juror's individual or the juror's collective thought processes. Okay, well, I would say, Judge, that's not what we want to do. We just want to ask them whether or not they acquitted on counts 1 and 3.
They keep burying the lead, which is what appears to be the case with the jurors is that there was no meeting of the minds in terms of what the court wanted them to do. And they didn't know how they were supposed to convey what they were supposed to be conveying. And if you focus on the form over substance to the point where somebody gets retried twice for murder, how can you allow that to happen? You can't. Flesh it out, do a hearing, take evidence, and then whatever the evidence is, issue an opinion. It's not that complicated.
It's not rocket science. It's not like it's not like a biomechanical engineer building a cannon to shoot a cocktail glass at a taillight to see how much force it would take for such cannon to break, or such cocktail glass to break it. I mean, that's rocket science. Cannon science.
If some of the jurors testify and they can ask them, well, how did you come up with the not guilty verdict? And maybe one of them will say, we just did. It just, the verdict.
Or I would hope one of them would say, it was the cannon for me.
It just spoke to me. Yeah.
Oh, now they're going to talk about why polling is improper. Likewise, polling the jury on the various possible verdicts during their deliberations or after their discharge would constitute an unwarranted and unwise intrusion into the province of the jury, and the Supreme Judicial Court has cautioned strongly against the risk of coercion inherent in questioning jurors, particularly in individual colloquies.
Again, they're not being called in necessarily against their will. They are volunteering to say that there was a miscarriage of justice from where we sit. So I agree that you can't set precedent that you can just haul jurors in. That would be terrible. I think anyone would understand you can't have jurors being intimidated and harassed. But why would you assume that these jurors are being coerced when they're basically calling a defense and reporting that 12 out of 12 jurors would say the same thing? Again, you don't have to rule tomorrow. You don't have to even order a hearing tomorrow. Let them develop the evidence, present it, see where it goes. If it doesn't go where they want it to go, they can withdraw the motion, but let them follow the evidence. How do you deny Karen Reed the right to follow the evidence, which may prove that she was acquitted on a charge that could result in life imprisonment? This is crazy.
This is Massachusetts. Quoting this case called Ray, says, moreover, quote, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. In many instances, asking a deadlocked jury about a partial verdict would constitute attempting to extract from the jury something that does not exist. Asking a jury to report where they stand on the offenses as charged invites a report that may be based only on preliminary tentative deliberation, if any, on that level of offense, or hasty resumption of deliberations concerning that level of offense in an effort to satisfy the judge's apparent desire for a decision. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of juror coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlocked jury.
Okay, so repeat after me. The jurors called the lawyers, the intermediaries called the lawyers and said right away, this is bad. Something bad happened. We're upset. We want to tell you. So far, it's 33% of them, allegedly. Some of them, or at least one of them, is claiming it's all 12 of them. This is not a process of hauling in jurors and trying to, I'm reading the language, extract from them something that doesn't exist. There is evidence that has been volunteered, so say the affirmations of the lawyers, by the jurors who sua sponte, I shouldn't talk lawyer talk, on their own came forward and volunteered this, but they didn't have to. And I think it's fair to say jurors do that for a pretty obvious reason, because it's eating away at them, okay? Because they saw what the yahoos on Twitter who were just lying and plagiarizing and making things up and said, this is crazy and this is wrong. And I didn't know this could be the case. And now she's going to get retried. And so that all of these cases about the concerns about coercion and whatever, they may not apply. Now, look, if you have one or more jurors who says, I don't want to come, I don't want to come, this is dangerous, and I don't like this, I'm being intimidated. Well, that's an argument that they could make. But right now, the evidence proffered by two distinguished lawyers is that we believe there are 4 jurors who have said this, and we have strong reason to believe that all 12 would.
And wouldn't you assume that if somebody out there was disagreeing with what these 4 jurors are allegedly saying, they would go to the Commonwealth and say, hell no, we did not agree that. And then they would have that in their papers.
100%. And by the way, for those who work on the theory that, you know, the Alberts and McCabe's had a plant in the jury. It would have happened if they did. They don't have a plant in the jury.
Yeah, no, I didn't buy any of that nonsense.
So that's too much. But yes, no, I think if these jurors who allegedly came forward were overstating this, I think there is a juror who would say, I want to be honest to the process. That's not accurate. And if one juror did that, it would probably kill the whole thing.
Yes, it would. But they would have had it in their papers because they waited long enough to respond that it was all public. It's been public for a couple of days, and they would have had it, and they would have attached it.
Happened because these people have consciences, and I think that they're troubled. And unless you're, you know, look, if you're going to subscribe to the Fakakta theory that these lawyers are making this up, get real. They're not making this up. Okay, they have better things to do. Yeah. Okay. They have a lot better things to do than waste time in preparing for a possible retrial than having to hire another lawyer because they might be witnesses in a hearing potentially about this issue. Okay. It's real and it deserves to be fleshed out. And the whole purpose of a hearing is that if there are credible facts put forward that warrant hearing this, then the answer is you ought to hear it. And that's all. Yeah. They may not win, but can you imagine? I mean, the fallout when this gets denied without.
You still think it's going to get denied? I don't think it's going to be denied. I don't think it can be.
No, I do. Why not? She can do whatever she wants.
Well, let's finish. We're almost at page 15, and then we'll argue that. Similarly, even if the deadlock does pertain to some distinction between the various levels of an offense, a judge has no way of knowing whether the jury have in fact fully considered the offense as charged. A desire to extract information from a deadlocked jury does not solve these significant problems in attempting to do so.
They're not saying they're deadlocked. That's, again, they keep ignoring. They don't want to talk about the substance of the affidavits. You would not know by reading these papers that this is not a situation where the defense has alleged without hearing from jurors or without them being contacted by jurors that this is what happened. If you read, you could as much conclude by reading these papers that the defense heard hearsay from hearsay from hearsay from a guy who knows another guy, and then contacted the jury and said, I heard that, you know, my guy on the jury said this. Mm-hmm. They're ignoring how this came to their attention. And by doing so, they're being intellectually dishonest in what they're reporting.
Mm-hmm.
Yep. Or arguing, I should say.
A court's inquiry into possible verdicts improperly intrudes on the jury's function, and the ostensible benefits to be gained by such a procedure are outweighed by its risks. For the foregoing reasons, we got one paragraph left. For the foregoing reasons, the defendant's motion should be denied, as there was no verdict that acquits the defendant, no grounds for the court or counsel to inquire into the deliberative process of a discharged jury. The defendant consented to the mistrial, and the court properly declared a mistrial due to a deadlocked jury who was at an impasse due to their starkly divided perspectives on the evidence and their sincere adherence to principles, individual principles, and moral convictions. As such, retrial is not barred by double jeopardy or constitutional principles, and the Commonwealth may retry the defendant on the 3 indictments and any appropriate lesser included offenses. XOXO, Michael Morrissey, loving kisses, Adam Lally, and Laura McLaughlin, and God save the Commonwealth.
You know, that last sentence before the conclusion is fascinating. And once again, it's like they're just boilerplate without thinking. And a court's inquiry into possible verdicts improperly intrudes on the jury's function, and the, quote, ostensible benefits to be gained are outweighed by its risk. Okay, the ostensible benefit is that an acquitted, not guilty or innocent, whatever you want to call her, woman who could have gotten life sentence is going to get retried and convicted of murder. That's kind of outweighs the problem with bringing in jurors who apparently are volunteering to come in. So I'm sorry, that's pathetic to say that and finish with that as your, you know, mic drop point. That's just stupid.
And on to that point, I can't see how she can deny this motion. People are saying, you know, why aren't there more jurors that came forward? We don't know. There could be. There could be more. Who knows? We don't know.
I think what you're going to see, and again, the judge has yielded control of this. She should have issued a scheduling order the day after this motion was filed, taken control. And, you know, she's just in the background while now all this is, the defense has filed 2 submissions. Now this one comes in because there's probably no scheduling order and it's chaos. I would assume that the defense is going to reply to this and tear it to shreds.
Hope so.
More in a PR sense than a legal one, meaning I think what they'll do is say shame on them for not even recognizing what's at stake here, that they have such low regard for the fact that an acquitted woman could be retried for the most serious crime in the penal law. And I'm sure they'll make other legal arguments about other stuff, but probably they will file more affirmations too. I mean, every time there's a news cycle on this, I would think that will increase the likelihood that other jurors will say, what do you mean they're saying, like, this is crazy?
Right.
Or do some of them go rogue and start talking now, which would be remarkable. I mean, I think probably not, but
Right.
depending on the personality of any individual juror, you see this response, you might say, you know what, I'm going to call someone. And, obviously they're going to listen to you. If you call and say, I'm a juror from that case and we acquitted, there isn't a reporter within 500 miles who's not going to say, let's talk and we'll protect you and all that.
Sue brings up a good point. How would the DA be reacting if it had been a unanimous guilty on 2 counts?
I mean, I think we know the answer to that. They would be.
They'd find other cases, or they'd spin these cases.
They would. I mean, look, I guess it's so abstract because the likelihood is so low. I mean, certainly given the count of murder, I mean, the idea that she would ever be convicted, but I think it's given the way these people behave and the things that they represent and say, it's fair to say that if the shoe is on the other foot here, that they would be running around saying she's guilty because the jurors called us and told us.
Right. Be very different.
I mean, but also it's very rare that jurors contact lawyers themselves. It's always the other way around.
Right. Although here they're not allowed to. So
right.
Science Sleuth, thanks for the 10. If evidence suggests the jury may have concluded on some counts, at a minimum, each juror should be questioned. If true, the ruling should be amended to reflect it. Otherwise, what is the point of our system?
I mean, the problem here, the balance is, it's interesting because I don't know if they even articulated this very well. 90% of their argument should be the policy problems with undoing verdicts or deliberations and bringing in, I mean, they do mention it a little bit. And, courts do not want to set precedent of every time a deliberation goes against you in some way that you can somehow relitigate what it is. But there are outliers. There are weird things that happen. There are weird cases. Things do happen. The law changes. This case is as crazy as it gets. The bottom line is they contacted these lawyers. And so it's real. You can't avert your eyes to this.
We're living in the world, in the land, in the time of social media. And this is just, things are going to happen like this. And jurors are going to be outraged. And people who live in Massachusetts already are outraged. Yeah. And the people sitting on this jury live in Norfolk County. So they know what's been going on for decades. And there's another thing that I wanted to mention. First, let's thank Susan. Thank you so much for your $50. I'm so glad I moved to New Hampshire instead of Massachusetts. I'd have Mark on retainer. Mark is a licensed to practice in New York and New Jersey.
Yeah, you can still do that. I could
and Pro Hoc Vice anywhere else, and he will happily be on retainer for anybody.
I love who wants to. I used to like to go to Canopy Lake Park when I was younger. Other places we like New Hampshire, Lake Winnipesaukee, all that kind of stuff.
Yeah. Lake Winnie.
Yeah.
Jimmy Fallon named one of his daughters Winnie because of Lake Winnipesaukee, because that's where they go.
Really?
To hang out. Yep.
My lab's name is Winnie, but that's because she's like female Winston Churchill.
Oh. Here's the thing about count 2, and I went back and watched the jury instructions on this. She said something in her instructions that say, if you believe that the defendant set in motion the chain of events that led to the death of Officer John O'Keefe, then you may find the defendant guilty. And it was very confusing. And so my thought is that maybe some of the people on the jury were thinking, she dropped him off there and it led to his death. So maybe that's the chain of events that they're talking about. It was very confusing. And I have to go back.
For that. I want to go back because that's like kind of a causal break kind of problem. Just because you did something that led to something, at some point it becomes attenuated. And the fact that she dropped him off and he gets killed, That
Right.
doesn't work. So yeah, I don't remember that, but
It was confusing to me, and I'm thinking, okay, this sounds like a negligence case,
yeah,
like causation.
right,
Okay, so duty, breach, causation, damages, that's
yeah,
negligence, but it's felony manslaughter. 20
right.
years, right? Is the max on that count.
I don't know off the top of my head.
I think you told me.
Probably did.
Melissa said the plan was to confuse and convolute the case and the jury all along. This was never about truth or justice and never will be. And a lot of people feel that way, Melissa.
Yeah. Well, it's going to get worse when you realize that this motion gets denied.
It better not get denied because there will be an uproar. There will be an uproar, and I'll be the first one screaming on here.
Yep.
Because there's no way in hell she can deny this, or at least deny further inquiry. I mean, come on. What are we
Get
doing
ready
here?
for it.
Alex, thanks for tuning in from Canada. Thanks, Mark. Mark and Melanie, great analysis. Tried to donate to the Karen Reed defense, but her law firm wouldn't accept support from Canada. Is there a web link to her cousin's fundraiser? You two are the best. Thank you so much. If Little Cupcake, if anybody else has the link, if you could drop that in the chat, please do. Thank you, Alex. I'm also going to put it under the description of this video. It is also under the description of the video that I just did with Craig Bates about 2 hours ago. We did it at 1:00 Eastern. So that video is up, and it was a great interview with Craig. So go back and watch that. Apparently, Kelly Reed, Karen's cousin, is in a competition with Paul Cristofaro, who says, for his $10, says, I love Kelly, but my popcorn is better. Let's make it a closer race. She's running away with it. Hit my link. One mod in here. Help a guy out. Hit me up for a link. Free
She's got
Karen
a
Reed.
huge advantage.
Paul.
Her name
Thanks,
is
Paul.
Reed. I mean, her name is Reed. That's tough to beat, I would think, in a competition like that.
I would think so.
Yeah.
But Paul, hey, if you want to throw Paul a bone, all the money's going to Karen's defense fund, so it's all going to a good place. And I think Kelly had raised something like this. Only went live this morning, and she was up to over $7,500, I think.
Wow.
Trevor, thank you so much for the 10. The big thing in the Blueford case highlights the fact the court in that case did their job in inquiring the jury's votes in each verdict. That wasn't even done here.
Yeah, I mean, I think that a lot of the things they did in that case were a little alarming. Again, the Arkansas procedure was a little shocking, but the bottom line is they did pin the case on the fact that they went back and deliberated. So therefore, we can't tell, whether the verdict that we were told was not guilty was final. I mean, that conceptually, that seems sensible. Here, they were done deliberating. So I don't know how you can use that case as the be all end all here. That doesn't make any sense to me.
Yeah, well, they do a lot of things that don't make any sense to me. Keith Incognito, so incognito, thanks for the 5, says, you two are a great combo, like Demi Moore and Tom Cruise 20 years after A Few Good Men. Yes, only 20 years after. Love you, Keith. Could Bev be an FBI target?
I don't know.
I think so.
I mean, who knows? But I don't think coming after her with, the queen of corruption is the right, without evidence, is the right approach.
You can't handle the truth. Wasn't that from A Few Good Men?
Bias, personality, not great, that sort of thing. I get it. But, calling her corrupt it's without evidence, that's a little strong.
Yeah. Justini, I'm looking for for the jury at the video of Bev declaring a mistrial. I have a memory, but want to watch again to verify. Hey, Justini, it's in my list under Mark and I did it together. It's a shorter stream. And I think the title is something like mistrial declared, or it's in the thumbnail. Jury hung, something like that, but you can find that kind of easily.
I'm sorry.
What was the date? Do you remember the date of that?
I don't
July
remember
1st?
the date, but I was going to say it might be subtitled. How the hell did this just happen?
WTF did we just watch? Usually I make the title before we do it. Sometimes I go back and change it. But yeah, WTF did we just watch? Dennis the Menace, thanks for the Canadian 5. Scott, that's for Kelly Reed, not Karen Reed. Don't know what that is referring to. Amy's Positive Pathways, they are not asking for deliberation. Acquittal of 1 and 3 to be confirmed. Yes, they don't want them to go back and deliberate, Amy. You're 100%.
That you could clearly never do.
Right. T-Tut, thanks for the 5. Can either of you think what strategy the defense may take now, says an eclectic mind?
Yeah, I think they're going to file.
Go for it, defense attorney. I'm going to give you the
file a response. I think they're going to come out swinging about some of the stuff that we talked about. If they have any other affirmations, I assume they'll file them. And then they'll ask for the right to present more evidence and or a hearing. But I would expect them to push back pretty strongly. I mean, the DA has left them a lot to work with, both in terms of rhetoric and law, it would seem. That's all I got.
It's going to be interesting. Yeah, no, I got you. Richard, thanks for becoming a member. John Beatabot, is Bev instructing don't touch the form till full verdict, a move that precludes partial acquittal, reversible error that can force appellate review?
Well, I mean, that's part of the problem, is that they may not have understood, and you kind of have to hear what they have to say about if they're so clear that they acquitted, why wasn't the judge told? I mean, I think that's a fair question, but I think it's one that everyone deserves an answer, particularly the defendant, who may have a huge constitutional violation be held against her if she doesn't get answers. So it seems like a no-brainer to me.
It seems like it, but who knows? Ashley, do you think the jurors are seeing all the coverage and want the truth to come out because of the corruption the jurors have seen now? Yeah, I do.
Yeah, I think they saw the nonsense tweets from towels and trolls, and ironically, this will all come back to being their fault. Yeah.
Mm-hmm. Bev to the dunking pond, says Dennis the Menace. Well, Mark, let's see here. I'd like to say how much I appreciate attorneys such as Melanie and Mark, who are clearly ethical in their views of this case. That speaks volumes of each your characters, in my opinion. Oh, thanks, Trish the Dish from New York. Fellow New Yorker, New York strong. Is it true that juries can't be pulled in Massachusetts? No.
I don't think so.
If you have a verdict, if you have a conviction or an acquittal, you can say, Judge, I'd like you to pull the jury. And then the judge asks each juror, is this your verdict? Is this your true verdict? And they would do that then, but you can't pull them during a hung situation. Chinatown, somebody likes that. Thanks, Caveman. Where are the slips? Did Bev shred them? She wasn't holding the slips when she had the note, so I don't know where the slips are.
I don't know,
Dennis, but and somebody says, why are Gwen says, why are the notes not part of the court record?
Because they're not
personal
evidence.
Notes.
I think they get impounded and either sealed or destroyed, but they're not evidence. They can't be used as evidence for anything. So they're basically non-existent.
Allison says, so you have to remember that these are the people who wanted to show her guilt because she was looking for a DUI lawyer, right, Allison? And we learned during some of this stuff that he was retained on the 29th right away. Marcello, love this duo. I was watching Mark with Brandy, and I love that whenever he's bored, he's like, all right, who's streaming or where should I be? Or, oh, did you go on Brandy's show?
No, not earlier. Not bored. I believe in working in spurts when you're writing. I'm writing a brief right now, and after like 3 or 4 good hours, I'm done for several hours, and then go back tomorrow and do more. It's kind of and if you start early enough, do that. Right. I don't like to cram, and I don't like to do 17 hours a day of this. So you get 4 good hours, put it aside, do 4 more the next day, that kind of thing. So
yeah,
and then this kind of stuff happens. It's a good distraction.
It's crazy because it always happens when I have something else scheduled or planned or I've got a thing. Deneen says, someone please answer this question. What can we as a people do, residents of the U.S., to bring this to the light, the corruption and law enforcement all the way across the board? Please answer if you know.
I don't know, but
vote. Yeah. Local elections are important.
Don't buy a house in Canton. I mean, I don't know.
Move out of Massachusetts. Yeah. No, but local elections are so important. A lot of people don't vote in off-year elections. Here in New York, we vote for judges. They're not appointed unless it's federal court, right? So vote for the judges, vote for the district attorney. When you have local, vote for your town board. Know who these people are. That's the way for you to get a voice in your community. There's no real petition or anything that you can sign, but you have to take the elections seriously, even the off-year ones where you don't think they're important. They are important.
Yep.
Marie asks Mark, do you think the defense should change the defenses in retrial? I think it was too confusing for all the players.
No, I think they should refocus. I wouldn't change it. I mean, but I would focus on the ARCA stuff, which shows that she's almost certainly not guilty, which I think leads to then how did the taillight get on the ground, which leads to it was planted, which leads to, well, who might do that, which leads to now disgraced and almost fired Michael Proctor and his partner Buchanan. And well, why do you think Proctor would do that? Because that leads to his texts about all the things that he did, including the Boston cop is fine. Well, then if Karen didn't do it, who did it? Who is he protecting? That leads to Brian Albert and those people. And their butt dials, text messages, Google search. So I wouldn't change any of that. I think what maybe they'll do in a retrial is not be so, you don't have to prove what happened. I mean, maybe they go a little less on it was Colin or it was this, or it had to be in the basement, as much as the ARCA witnesses established it's not Karen Reed and the taillight didn't get there from a car accident. So that means it was planted and they were covering up for people. And the people they were covering up are these so-called McAlberts. And what are they covering up? I don't know, but it had to be something related to this and go from there. Then how does she not get acquitted? So I think in any retrial, you just fine tune it, but they're not going to abandon, their position in terms of what their defense is. I don't think.
Yeah, it can be streamlined a little bit more, perhaps. And now they know everything that the prosecution has or doesn't have. And that inverted Sallyport video to me is a huge deal.
Huge. And if they solve that, I don't think there could be a retrial. I mean, if you can prove who's corrupt and all of that, I think it's over. And I think if there is a retrial, even though I don't think there will be, I think they'll lead with the ARCA stuff. I think logically, the argument makes sense to start with already, she's not guilty, and it leads to the taillight, it leads to the corruption, it leads to the cover up, it leads to the people in the house. And I think that might flow better than just, all of this going in random directions, but they'll figure it out. They know what they're doing. Obviously,
that was the fault of the the Commonwealth for putting on such a disjointed case that really had no chronological order or rhyme or reason to it. We didn't hear how John O'Keefe died until like the last two witnesses. Like, it was insanity.
Insane.
Why don't you start off every trial like, this is what happened, this is how the person died? It like they didn't. I think they did in Alec Baldwin. I honestly have not been watching it. But I think the first day they showed a video of exactly what happened or something like that. If you guys are watching Alec Baldwin, let me know. But wouldn't that be the natural way to start off your case?
My God, it's insane what they did. And, you have to also wonder if the DA doesn't do that the second time, because, if you make the defense call these witnesses on direct, it becomes much harder. I mean, direct examination of Jennifer McCabe is going to be much harder than cross-examination, given how wild and unpredictable she is and lashing out and all of her stuff. And when she has a license to be asked open-ended questions, get the earplugs out, because you're going to be there for a long time and it's going to be quite shrill. So Brian Albert's another one. He was pretty tough cookie when he was testifying. He was pretty well in control, even though some of his testimony didn't make any sense. But if you have to direct him, that's going to be harder. Same with all of these. So I would expect the DA, they'll adjust too if it really goes forward.
Don't be hating. Thanks for 10. Bederow has been defending John. What did you pronounce? Juka? Is that how you say that?
Yeah.
An innocent man who's been in jail for 20 years. This could be any of us. Thanks, Melanie and Mark, for exposing and fighting against injustice.
Thank you.
Summer says, was the jury waiting for the judge to ask them, what's your verdict, like we see on TV? Instead, she dismissed them to wait for her.
Kind of feels that way, but we don't know, because they're not allowed to, apparently, in the current format, say anything, we're told.
Busted Flesh, where do I look to research judges in my county? I've looked and tried to research their cases and how they ruled. Nothing.
I don't know.
I don't know either. I don't know where you live, so it's hard. All right, I have a couple more people to thank here. I don't know if you want to stick around, if you want to go. Where can people find you tonight?
I'm going to talk to Brian.
At LTL?
TL.
Oh, cool.
Yeah. So I'm going to jump off now because I'm going to get some dinner and
do some writing, do some dinner. And then what time are you over there?
They're writing. 6 o'clock. What time is it now? Yeah. So I'll
4:44.
Yeah. And,
all right, I'll redirect everyone over to that channel for that show, because I'm nice like that and I love Brian, so I'll do that. But thank you for coming on. Any final thoughts before you go and I finish up with some questions here?
I think she's going to deny it. I'm not saying it's the right thing to do. I don't think she should. I think it would be terrible, but I think she's going to deny it. And I think you're going to see a ruckus about this, an outrage. And I think ultimately it's going to lead to jurors taking this in their own hands, which is exactly, ironically, what you don't want. You don't want to make this about jurors, but they want to be heard. They want to, explain, and I think they want to clear their conscience, and they're being told they can't. So what else can they do other than hold it in, other than talk to people about it? And I think that's what they're going to do.
All right. Well, you heard it here first, folks. Thank you for coming. And
Okay.
we will talk to you later. Go have some dinner.
Right. I'm going to eat something. Take care. Bye.
All right. Bye. Well, that was fun, wasn't it? It's always fun with Mark. On top, thank you, Voyo Supersticker. Melly. Hi, Melly. You're a member a month with the amazing cupcakes. Adore you, Mel. I adore you right back, Melly. Lori, Life 360 for the win. Thanks for gifting 5 memberships. You're so kind and generous. I'm just a girl in the world. Thanks to 5. So glad I set my bell to alert me to your lives. Great seeing 2 brilliant legal minds to come together. See, this one was just like a last minute one. So that's why you want to hit the bell and you want to hit subscribe. It's free right below the video. You might have to close out the chat to do it because of the new YouTube format, but you don't want to miss it. Thanks for the super stickers from Lynn, and don't be hating. Spirit Healing, thank you for the 10. The only way she started the chain of events was texting that psychopath, I guess you mean Higgins, who obviously couldn't handle the fact that she ignored him. He was like an egomaniac on the stand. You think? I think so too. I agree with you. Arizona Farrell, the rebuttal is going to be epic. Oh, it's going to be epic. I'm here for it. I'm here for it. And Melissa, thank you so much. Please don't forget to help Kelly Reed win the competition of the popcorn sales for Karen's defense firm. Thank you so much. Kimberly said, thanks for having Craig. Thank you for the Venmo donation. And thank you to Just a Girl in the World for buying me a matcha latte, and for Kamala for the Cash App, and says, love Mark also. And you guys are awesome. Awesome. And I could not do this without you or my moderators. My moderators keep this chat classy. This was a totally last minute thing that I literally scheduled while I was doing the interview with Craig earlier. So if you didn't watch that, go back and watch it. I'm going to redirect you guys over to LTL True Crime for the 6 o'clock show, where you can watch Mark again if you so choose. So let's do that, and I will teleport you over there because that's what I do for my buddies. And hit the like bell over there, even if you can't stay for the show. That way you can hit the reaction, and then you can remind yourself to go back and watch it. I believe it is scheduled for 6 p.m. Eastern. Thank you also very much for coming and for spending so many hours with me since I did the first show at 1. It's been 4 hours in 2 different shows. So thank you so much for keeping it classy. This is a hard case to cover a lot of times in many ways because there's so much vitriol around it. Thanks, Melissa. Summer, if the judge denies, can they appeal? Yes. We'll see what happens, though. Let's see what happens. They may not want to appeal because it would stay the retrial. So there's a lot of issues in play there. And I think, thank you, Black Rose, for telling everyone, reminding everyone to hit the like button. Uh-oh, Paul must concede to Kelly now, says Florida Tim. She's less than $300 away from $10,000 in the fundraiser. Yay, Kelly. I'm rooting for you, Kelly. All right, you guys. Go back and watch that stream I did with Craig if you missed it. It was at 1 p.m. Eastern, and it was a great interview. Craig of the Tiny Desk in the courtroom of the Karen Reed trial. He was in charge of all the exhibits, and he has his own company in California doing trial support, litigation support, defense exhibits, and it was a fascinating conversation. I will see you all very soon, but you won't know when unless you hit the bell and the subscribe button. It's totally free. Thanks, moderators, for keeping everything classy today. My members for loving me enough to want to join my community. This is a great community that we have. I skipped your super chat. What did it say, Gringa? I didn't see it. They were not getting starred and put into the right column. Can you just type your question in there real fast and I'll do it? StreamYard is like breaking today. Just type it in as a regular question, Gringa, and I'll wait for you. Kelly, I love you right back, Kelly. Everyone, please hit the like. So as I was reading the documents, I had to close the comments because the font was so small. And it may have gotten lost because it was not. StreamYard is supposed to star them. Okay, here we go. And then put them in a separate column, which makes it easy for people like me who are doing 12 different things at once. But Gringa, thank you so much for your super chat that I did not see. Is there any credible evidence regarding John O'Keefe's connection to the Sandra Birchmore investigation? I do not know. I do not know. It has since come out that there is credible evidence that John O'Keefe did report to the Canton PD, I believe, some instances of perhaps drug dealing in his neighborhood. That, I believe, has been confirmed. I do not know if he had any connection to the Sandra Birchmore investigation. That I cannot confirm. Can anybody in the chat confirm that? Because I do not know. He was not involved in the investigation. I did one episode on Sandra Birchmore so far. We went over the civil complaint in addition to the Canton PD reports. I have yet to do the next episode too. Will be on the Massachusetts State Police reports. And there are a lot of the same players involved. Sergeant Lank was involved in that investigation. That, my friends, John did not have any part of Sandra Birchmore, says Suzanne. Thank you, Suzanne, for answering Gringa. We appreciate you because I know you've got a lot of information on these things. So, Suzanne, I trust her sources. So we do not know. But she says no. A couple people say no. That's it. All right. As I say at the end of every stream, be cool, be kind, be classy, my friends. It is not hard, really. It's so not hard. Please do the YouTube-ish like things and hit the like button, hit the subscribe, the bell, do all the things that YouTube likes for the algorithm so that people will get this stream in their feed and they'll see it. Thank you. I'll see you real soon. Peace out. Have a great night, my friends. Have a great night.